Okay, we are rolling. Jasper, let's start a little bit about growing up in.
Columbia, South Carolina.
Okay,
I grew up primarily in Columbia, South Carolina. My mother and father were separated. My father lived in Washington, D.C. He was a construction worker. And my mother was a domestic worker in Columbia. And I was born in 1946, so I grew up in the 50s and 60s. And I would like to think I came of age somewhat in the 60s. And of course, during that period, it was a period of strict segregation. The schools were segregated, workplaces were segregated, buses, sitting on a bus, the simple act of sitting on a bus was segregated. I personally sat in the back of many buses. I recall seeing the first black police officer. We had no black judges when I was coming up. There were most of the businesses were separate black businesses, separate majority white businesses. The whole society was segregated, and I went to black high school, black elementary school. All the schools I attended were black. My teachers were black. However, I think to a certain degree, I was in a cocoon. I was sort of protected from the issues that were going around me, from the hardcore segregation. Usually in those cases, if you stayed in your segregated area, most of the time you didn't encounter hardcore acts of racial discrimination. But you couldn't stay in your cocoon all the time. You had to go to work. You had to get to school, which means you had to sit in a bus, in the back. You had to do some things where you interacted with the larger society. And that's where a lot of the conflicts came up. I grew up during the era, I was a teenager in the 1960s. And during that era, it was a dynamic era. It was a wonderful era in the sense that there was an era of change. We were demonstrating simply for the right to sit at lunch counters, to sit anywhere we wanted on buses, to attend certain events in an integrated fashion, and to a lesser extent to have certain jobs. So that brought on a lot of conflicts, and I participated in marches, sit-ins, all of these things as I was a teenager. But primarily during my teenage years, my mother was essentially a single parent. Even though she wasn't divorced, she and my father were separated for 16 years, from the time I was born until I was 16. And she was working as a domestic worker, trying to educate her 3 children. So I had to work. My sisters worked to help her. And I also played sports, football and basketball. And so I was trying to balance all of those things. And that was my primary focus during those years, my developing years. And I'll always appreciate the teachers and instructors at my high school, Booker T. Washington High School, for their support and guidance.
Okay, hang on just one sec.
Okay.
Okay, yeah. Moving on to Hampton, we should probably get to.
Okay. I was an athlete in high school, and my best sport was probably football. However, my senior year, I broke my leg. And my coach saw me moping around the school, and he pulled me aside and told me that I should pick my head up and I should apply to Hampton, and that he would contact them and try to give me some support on that. Well, my leg healed to a certain extent. However, the summer, immediately before I attended Hampton, I re-injured the same knee. And my mother asked me what I was going to do. And I didn't know how I was going to do this because I didn't have any money and I wouldn't have a scholarship because the condition was that I make the team. I told her I was going to school. So I showed up at Hampton. And one of the ladies in the business office told me that she knew of my circumstance and she allowed me to register with the condition that I pay them as I could. I'm always forever grateful for Hampton Institute for allowing me to matriculate. So I attended Hampton, participated in all types of activities. Never did play football, but I did play baseball. But the activity that really helped me get my degree primarily was a work-study program. I got in a cooperative education work-study program where you work one semester and you were back in school the next, and they graded you for it. So in that program, I was able to make enough money to pay my fees and pay my expenses and go ahead and continue with my education. Got my education at Hampton Institute, graduated in January of '69, and I went to work. I worked for about 3 or 4 years, and then I decided, at the urging of a roommate of mine, to go to law school. And I applied for several schools, and I got accepted at Catholic University. And I attended Catholic University. And while attending Catholic, I worked on various jobs. You name it, if it was legal, I had that job. I worked for EEOC one semester. I worked for Gallaudet University as a counselor. It's a deaf school. I had several other jobs. And so I was able to complete my law degree at the Columbus School of Law at Catholic University in 1974. 74 was a crucial year for me. I graduated, I took the bar, I got married, and my wife and I had a daughter the following year. And as you might recall, that was the year that Richard Nixon resigned from the presidency. So the hearings on Richard Nixon was really sort of my relief from all the studying that I had to do. I remember hearing Barbara Jordan, especially. She was a very eloquent person, and she gave me a lot of just enlightenment. Started working I intended to go into criminal law, but that didn't quite work out. And I got a job with the Labor Board there in Washington, D.C. And the purpose of the Labor Board primarily is to run the union elections, certify and decertify unions, and to prosecute unfair labor practices based upon union activity and what's called protected concerted activity. Protected concerted activity is simply group activity where employees come together to try to improve their working conditions, and if they're retaliated against because they do that, then that's against the law. That's a short version of what the Labor Board does. I started working in the advice branch in Washington, D.C., And in advice, basically it was back in law school. I was researching and writing. And that wasn't my forte. So I was trying my best to get to the field office where I could serve as an attorney, a field attorney. And a field attorney simply basically operates almost as if it's in private practice. You investigate cases, you try cases, you conduct elections, you hold hearings, you write briefs, you do everything that someone in private practice would do. So I got an opportunity while I was in the advice branch to go down to Atlanta on what we call a detail. And the Atlanta office covers Georgia and part of Alabama. So I got some actual trial experience in the Atlanta office. They assigned me to work with one of the senior attorneys, a fellow named Thad Sobieski. And Sobieski was a good attorney, a very experienced attorney, and most significantly, he was willing to give me the benefit of a lot of his knowledge. So I was not quite sure where I was going with this labor stuff, because I still hadn't fully immersed myself in doing what I wanted to do. Sobieski and I had a case in Columbus, Georgia. It's called Columbus Foundry versus Willie Griffin. And Sobie, as I call him, basically said to me that I was going to do the case. I was going to prepare the case and put the case on for trial. And this case, briefly, involved a gentleman named Willie Griffin, who was a shop steward. They had a union in the plant, and he was known to stand up for the employees. On one evening, a couple of employees were working under a platform, and one of them was accused of smoking some marijuana by a supervisor. The supervisor took both the employees who were working together under the platform in a room to have a meeting. Mr. Griffin asked the employees if they wanted representation, they wanted him to come in, and they did. They said yes, they did. He went into the meeting. An argument ensued over his presence there, and it resulted in the company terminating Mr. Griffin. They also fired one of the employees who was accused of smoking marijuana, and they let the other employee go back to work. So that's essentially what the case was all about. Well, we're preparing the case. It falls under a old Supreme Court case called Weingarten. So we're preparing the case for trial. I got to meet with Mr. Griffin to prepare him for his testimony, and I got to continue to investigate the case. And I think the night before the trial, the company offered him a settlement. And they offered him a monetary settlement, but no reinstatement. Christmas was coming up. He had two small children, and a wife. And his wife, I remember his wife called me, and she told me that he had been offered a settlement, and she wanted me to talk to him because her children would not have Christmas, any toys for the Christmas. And she implored me to talk to Willie to get him to accept the settlement. And I told her that it was his call, but I would talk to him. He came in that evening, and I met with him, and I told him that his wife had called me, and he said he knew. And I said, I'm obligated to give you both sides of the coin. I said, now, I think it's a good case, but we may lose the case. And I said, the company, by this time, the gentleman that they had fired had been reinstated. All right. And I said, Willie, the reason they probably reinstated him is to testify against you. And I said, I think I can handle it, but I think you need to be aware of that. I said, now what do you want to do? He told me, in essence, that they had been treated unfairly, treated poorly for a long time, and he just wanted his day in court. And that really struck with me because I said, here's a guy who's lost his job, He's got 2 small children, and he's got his wife. His wife is on his case, and yet he still wants to go. He has no guarantees that we'll win this case, but he still wants to go forward. That inspired me, and it gave me the strength and it let me know that this is what I wanted to do. Fortunately, we put the case on, we tried the case, and we won the case. Mr. Griffin was entitled to his reinstatement and back pay. And that was a significant point in my career, because it let me know that this is the kind of work that I wanted to do.
Okay, hang on just one second. I want to maybe, I'm going to stop it for just 1 second.
Okay.
Okay, so yeah, in terms of the racial aspects of this case.
Okay. This case, in my opinion, demonstrates the connection between race and union rights and civil rights. Willie Griffin was black. The 2 individuals that he was trying to represent were black. All of the company supervisors were white. And Willie Griffin was a person who was strongly supportive of employees being treated fairly. And that's what he was about. Without his presence there, the company could treat these employees just about any way they want. In my view, the strength of having unions and having a union in a plant, in an employment situation, is that you get a voice. Essentially, I refer to it as democracy in the workplace. Without a union, employees do not have a voice. A company may listen to you and they may not. But if you've got a union and you have a contract, you have a voice. You have someone to speak for you, and you can speak for yourself. And there's more of a semblance of justice in the workplace. So this case sort of demonstrates why the company, number one, was so adamant to terminate Willie Griffin. They knew that Willie Griffin was a strong voice for the workers, and that they couldn't treat the workers in any way they chose. They had to follow the terms of the contract. And if they got rid of Willie Griffin, they could treat the employees any way they want. In this case, also, there was another union official who was not as strong as a union person as Willie Griffin. That individual ended up testifying on behalf of the company against Willie Griffin. You know, it seems ironic and doesn't seem to be fair, but that's what happened. But Willie Griffin was someone that they knew they had. Let me get this.
Okay, so we are rolling. Go ahead. Yeah, let's move toward wrapping up.
All right. This is
Columbus
Columbus founded.
I'm just what percent? In other words, were most of the workers black or at this place?
I think most of the workers were black in this facility. A large percentage of them were, but insofar as the civil rights connection with labor and this particular plant, I think it illustrates that just as you know, in civil rights law, you're seeking fairness in housing and fairness in public accommodations and things of that nature. Here, these employees were seeking fairness in their working conditions, to be treated fairly, not being subject to arbitrary terminations and discharges without having a voice. And I think Mr. Willie Griffin is the embodiment of that right. So that's why the case was so meaningful to me early in my career. And this was 1976.
And how much talk about the settlement?
Well, he got reinstatement. got his job back with benefits, and the dollar amount wasn't very much. It was probably in the neighborhood of anywhere from $5,000 to $10,000 for the period that he was out. Under our statute at the Labor Board, employees are not entitled to punitive damages, but only to actual back pay, what they actually lost. So, but the big point for him was getting his job back and having his day in court, and that did happen. So.
And how much was the settlement with the company?
Well, that was the company had to pay his total back pay, whatever that was, and I'm not sure exactly what that was. That was just for him. Now they also reinstated the other employee, but they reinstated the other employee that he was attempting to represent through the grievance process. But this case only, the complaint in this case only involved him, alleged that he was unlawfully terminated.
Okay. Well,
but understand this, he was the guy they really wanted to terminate because he was trying to hold their feet to the fire to make them follow the rules of the contract.
Right. Yeah, okay. So most of the supervisors at this facility were white.
That's correct. That's correct.
And what was the union involved?
That was the steelworkers local. And I can't speak to how supportive and active they were, but the union is only as strong as its strongest members or weak as its weakest members. And Willie Griffin was clearly a strong union committeeman.
That's great. Well, so then, as an attorney, talk about when did you move to the NLRB? Was it Region 11 here in Winston?
Yes.
Talk about that a little bit.
Okay. Well, I was working in Georgia on a detail with the understanding that I would come back to Washington. And I was permanently assigned to the advice branch in Washington. So I went down there simply to get some experience. When I came back, I had already put in some applications to transfer, but they were kind of on hold. I had attempted, I was actually living in Maryland, right outside of Washington, and I was hoping to transfer to the field office in Baltimore. But I went over and interviewed while I was working for the Labor Board. I interviewed for a position that they had open, and they told me that they didn't have a position open. When I informed them that one of my law school classmates had worked there and that he was leaving, and that he was the one who told me about the opening, it kind of surprised them, and they said that yeah, it was true he was leaving, but they weren't going to replace him. Well, I filed an EEO complaint and alleging the denial of transfer. All I wanted was a transfer from the Washington office to the Baltimore office, where the field work was being done. And that was pending when I went to Atlanta. So when I met with their official before, he had indicated that I didn't have any experience doing field work. And I said, well, but after I tried this case and after I had the experience in Columbus, in Atlanta region and trying this case, they could no longer say I had no experience. So we ended up settling my EEO complaint. And the settlement resulted in my coming to North Carolina. That's how I got to North Carolina. So I came down here and in the late 70s, and this region covers North and South Carolina. At that time, it covered North and South Carolina, part of Virginia, and a couple of counties in West Virginia. So the majority of my 40 years with the Labor Board was spent in this region, in working in North and South Carolina and Virginia, Southwest Virginia, in the coal mining area, as well as a few counties in West Virginia.
So what year did you start up here in Winston?
I started here, I think it was about 77 or 78, and I've been here ever since. And I continued working in Winston throughout all of North Carolina, all of South Carolina, and throughout the southwest corner of Virginia. I worked many cases up there in the coal mining area. Had a number of small cases, large cases. The most significant cases I had were Holly Farms Tyson, where I represented 200 truck drivers who were terminated. They were fired because they engaged in union activity. And we won that case. That case went to the U.S. Supreme Court. I didn't try the case in the Supreme Court. I tried the original trial. And they appealed it and continued to appeal it. And the case was upheld by the Supreme. We won the original and it was upheld all the way up. The issue before the Supreme Court was that the company alleged that the truck drivers were farm workers who wouldn't be covered under our act. And the court said no, they were covered. They were covered by the act, just like any truck driver would. They had to go out at night and catch the chicken and put them in these chicken coops. That was part of their job, in addition to driving the trucks. And that's why the company was alleging that they were farm workers. But that didn't work, and we won that case, and the union was the collective bargaining representative. This is when Tyson took over Holly Farms, and the union became the exclusive collective bargaining representative for those employees. Of course, you're well aware that I tried the Smithfield packing case, and that case was a long, difficult, sometimes complicated case. The union campaign lasted 16 years. My part in it, the trial that I worked on, where I represented a number of workers, lasted approximately 7 months. It was in Bladen County, which is a rural county in North Carolina. And I would leave on Sunday, go down and work on the case. We'd have the trial from Monday through Friday, and I'd come back on Friday only to repeat that process. And the case was before Administrative Law Judge West. He was a very good judge, and he really handled that case quite well. In that case, it was a case that had some of everything that happened.
What's that? Oh, I'm sorry. I heard something.
Oh, that might have been in the room. A couple of significant things in that case, had an employee who was a very strong union person, and this employee was fired, and he helped me find witnesses. That's a rural county, and I really appreciated his help. He was very active in the union, and unfortunately, his name escapes me right now. It'll come back to me. And then I had a former supervisor who had fired a couple of employees who were in the complaint. And if you're no longer working for the company, then I can approach it. So I approached her, and I got her involved. She testified in the trial. Well, I went to her house 4 or 5 times at least. She lived on a farm. And I noticed that people were following me. So I got followed practically every time I went to her house. She testified for 3 days in that case. and she was very instrumental in helping us to win that case. But we won the case. It was about the year 2000 when we got the decision. We won practically everything in the case. There were over 200 issues, separate issues. Threats, terminations, warnings, promises of benefits, all of just about anything they could do to undermine the union effort in that case. A lot of civil rights people were involved in that union campaign. There were actually three separate campaigns. First one was in '94. They had an election. The union lost that election. They had another, and the company fired some people. They had another election in '97. The union lost that one, and the company fired some more people, and they engaged in threats and just numerous threats. And then we had the trial in '98, and we got the decision in 2000. The case went all the way up to the Court of Appeals about 2006. The Court of Appeals upheld the decision of the judge, ordering the company to cease its threats, cease all its unlawful activities, reinstate the employees with back pay, and to run a third election. There was some reluctance on the part of all the parties to run a third election, but the employees in this case were just courageous employees, and they insisted that the union run a third election. The union ran a third election, and the union won. They are still representing the employees in that plant today, giving them better wages, better working conditions, and just a better environment. And that working in a slaughter plant is very difficult under any circumstance. So you need representation in those circumstances. So I'm glad to say that I was a part of that, and that we were victorious in helping those employees seek representation in a rural county where even though it's a difficult job, that's the best job probably for working people in that county. You're talking about 5,000 employees processing over 32,000 hogs a day, and under very severe circumstances. That was a very tough case, and it was one of the larger cases that I tried. So.
Well, let's talk. Yeah, in terms of the Smithfield case, talk about, in other words, Bladen County is
Very poor county.
Yeah.
Yes.
So what were the racial aspects? I know that they had a lot of Hispanic people there.
Yeah.
African American, but what about the racial aspects of that case? Of course, now I assume a lot of the supervisors were white.
Yeah. Some blacks. Well, you're right. Race was a major factor in that case, as it is in most labor cases in the South. The undercurrent of race. Oftentimes, the African American employees don't feel like they're being treated fairly, and in terms of working conditions, in terms of discipline, and promotion, all of that. And that's not unusual. And in this case, you've got whites, African Americans, you've got Hispanics, and you've got Native Americans who, the Lumbee tribe has been in that area long before anybody, and they are entrenched in that area. What the company did is the company further injected race, more so than it normally would be, to divide the blacks from the whites, the blacks from the Hispanics. They would have separate meetings, what we call captive audience meetings, with the Hispanics, railing against the union, telling the Hispanics that they didn't want to be involved in the union, that the union would contact the immigration service on them, threatening them with expulsion from the company. All of that was in the complaint, and to try to divide them. In my trial, I probably had over 50 witnesses, and I should have had a lot more. But in my attempt to try to get employees to come forward to testify, I had a very, very difficult time to try to get the Hispanic workers to participate because they were afraid, not only for their job, they were afraid of being kicked out of the country. And that point was brought home by the company. It's sort of, I did this work for over 40 years. I would say the majority of the cases that I did here in the Carolinas, in the South, the company usually at some point or another pitted one race against the other to try to divide and conquer the employees, to keep them from coming together to form a union that would protect all employees. That was a constant theme in many of these cases. And in this case, in this Smithfield Packing case, you had a number of civil rights people who were actively involved in supporting the union. Reverend Jesse Jackson came down and spoke. Reverend, I can't think of his name. Reverend Barber, thank you. Reverend Barber was very active here in North Carolina and throughout the country, was supportive of the employees during this campaign. And many, many others were very active in supporting the employees. But ultimately, the support of all those people is good, but it was the strength of those employees who wouldn't give up the fight to try to bring a union in that plant. And that case always inspires me because usually people kind of, after a certain period of time, they may give up. These employees continued to fight for over 16 years. And they finally got a union in the plant. They got pay raises, they got better working conditions, and generally they just got better treatment because they persevered. And I take my hat off to them.
Right. Okay, hang on, I'm going to...
I thought about a case I had in Sanford. I ended up trying that case twice, same case. The judge tried the case, held the case, and he died. And they made us try it again. And I thought about some of the circumstances involved in that case.
You've been through a lot of stuff.
Oh man, yeah.
Well, back to briefly the Smithfield case, because it's interesting. The company, as we know, did everything they could, including having a private police force, and they were really pretty outrageous what they tried to do or did do.
Yeah.
But talk a little bit about so there were African American employees, there are also Hispanics, some of whom were not documented.
Right.
So there was racism going a lot of different, not just, again, they talk about a little that divide and conquer thing.
The company would, as most companies do when they're having their anti-union campaign, they bring in consultants. And the purpose of these consultants, we call them union busters. The purpose of these consultants, especially in the South, where you've got a large populations of minorities, blacks and Hispanics especially. And in this case, you got blacks, Hispanics, and Native Americans, is to have those groups pitted against each other. And that's what the company did in Smithfield. They would have these captive audience meetings, we call them, where you're required to attend a meeting during your work time. They pay you for it, and you have to sit there and listen to these consultants tell you bad things about the union. The union is going to cause you to lose your job. The union is going to cause the plant to close. The union is going to cause you to get have your pay reduced. All of these things, these are threats that are against the law. But they say those things. And in these meetings, Smithfield would have captive audience meetings with only Hispanics. They wouldn't let the other employees attend, especially vocal black employees, because they thought that these black employees would disrupt the meeting. All right? And that was a way that they used to get the allegiance and the support against the union on behalf for the Hispanic employees. One of the significant things that happened to bring this point home, there was a captive audience meeting among the employees in a particular department. And there was a lady who attended the meeting who had worked up north. And she moved back to that area, and she worked in a union shop up north. So the company attorney was conducting the meeting, and he was saying some things that this lady did not agree with, which she felt was totally wrong. Well, there were probably 200 or 300 people, employees in this meeting. She stood up and she told him, she was a very strong person. She told him that what he was saying was wrong and that he needed to correct it, and she wanted to correct it. Well, he felt that this put down in front of all these employees, was detrimental to his representation and all of that, really his ego. So he went to her supervisor right after the meeting and told her to fire her. And he didn't use those words. All right. Her supervisor told him that she didn't have anything on her, there wasn't any reason to fire her. He said, go ahead and fire her and I'll take care of the consequence. Supervisor fired her. And she was one of my discriminatees that I represented in this case. But she was a black employee, and he also told the supervisor that that area, where that department where she was a hornet's nest of support where the employees supported the union. And he wanted that cleaned up. He wanted that department, wanted her to get rid of all those employees who supported the union in that department. So that kind of brings it to the fore.
Did he use the N-word?
No, not. What he said was, he said, fire the bitch. If I can say that word, excuse my language. Fire the bitch and I'll take care of her at trial. And she testified and we got her job back. We had another situation. It was kind of, it's not so much racial, but it was kind of funny. There's a lady they call Granny in the department, and I can't think of her. It's been a number of years. Well, Granny was a little bit older than most of the employees, as you might imagine, and she was well thought of by the employees and by management. If she had something to say, she didn't have to go just to her supervisor. She could go to the plant manager directly, and he would listen to her. Employees listened to her. She was a person of note in that plant. And when Jesse Jackson came down to give a speech, it was well publicized. Well, she wanted to go and see Jesse Jackson. Well, Granny was a white person. And generally speaking, the white employees did not support the union to the same degree as the minority employees. So Granny went to this rally, saw Jesse Jackson, and after the rally, she got interviewed on the local newspaper and in the news, on the local TV, and she said she was now supporting the union. Oh, the plant manager was just totally upset. He was being ribbed by his fellow supervisors, so he went to see Granny directly. He told Granny that he wanted her to renounce her support for the union, that she had let him down, and he wanted her to take all of that back. And Granny said, "I'm not going to do it." Granny was fired shortly thereafter. And they fired her allegedly because she threatened a young employee, someone young enough to be her grandson, who was well over 6 feet and over 200 pounds. And the judge took it as most of us did, as a joke. What her comments was, she issued the tickets for the smocks. And sometimes the employees would play a game. They would take the ticket back once they got the smock, rather than give it to her. And Granny commented to him, she said, "Don't make me come over this counter after you." You know, it was a joke. I mean, here's a little lady, 5'4", 140 pounds, who's going to do damage to someone 3 times her size. All right? So I didn't worry about that case. I knew I was going to win that case. But that was a case that had a little humor to the whole trial.
Well, let me ask you this. First of all, were there other African Americans who worked for the NLRB besides yourself, like at the office here?
Yes. In my office, there were about approximately 20 professionals. And during the time I was there were 2 or 3 black attorneys and 1 black field examiner. All of us, everybody did everything. The attorneys, the investigators generally investigated the cases, and they conducted the elections. The attorneys didn't do as many investigations or elections, but we were required to do some of everything. One of the outstanding, great attorneys in the office was a gentleman named Paris Favors. He tried a number of the landmark cases, J.P. Stevens cases like that, while he was there. He was there before I was there, and I learned a great deal from him. Unfortunately, he was a black attorney. He had a heart attack right there in the office. And I was in the office and I assisted one of the secretaries in giving him CPR, but he passed away. Only 45 years old. Had a heart attack and died right there in the office. It was a sad thing. So the employees came together, and we have a hearing room. They named the hearing room after him. But he was an outstanding lawyer. Just can't say enough good about him. And he, I'd always confer with him on various matters, various cases, just life things. But he was a great attorney, and so all of us worked together. We got along in the office for the most part pretty well. Everybody got along. We were all doing the same work, and we would confer. And the older attorneys would advise the younger attorneys, and we had sort of a mentoring process. It wasn't formalized, but before you went out, if you were a young attorney, before you went out on a case, you usually would go out with a more senior attorney. And as you progressed in experience, your cases became they gave you more and more complicated and difficult cases. And usually, when I got to be more of a senior attorney, most of the difficult, complicated, convoluted cases, especially if they involve blacks in the low country of South Carolina or anywhere in South Carolina. Since I am a South Carolinian, and I didn't mind those cases because they knew I could relate to the folks. My forte I feel working at the labor board was being able to talk to anybody. And some people they have a hard time going to trailer parks and going places that you have to go, rural areas, dirt roads, and in rural areas and all that. But having grown up in South Carolina, I never had a problem with that. In fact, I'll say this, I've had at least a couple of cases where I've represented Klansmen. At one case in Fayetteville, where these guys were drink truck drivers. They drove these trucks that deliver soda drinks to the rural stores in their rural areas, and they decided to organize a union. And the leader of that group, just so happened, was also a Klansman. And I didn't investigate the case. When I got the case, they assigned me the case. In his statement, the way I found out about him being a Klansman was the supervisor interrogated him about this union activity and said that the supervisor said, well, I heard that you were trying to organize a union. He said, no, the only thing I'm trying to organize is my chapter of the Klan. So I'm reading this before I meet the man. And of course, I wasn't too keen on representing him, but that's my job. So I go down there, and when I went down there, I said to myself, the first thing I got to do is get some understanding with this gentleman about his Klan activity and let him know what I'm about. So I told him that this was my job. I had read where he was trying to organize, he was in the Klan. And I told him that, that was his business, but my business was trying to represent him. If he had a problem with that, let's get it out right now. Maybe they'll send somebody else down here. I was hoping he'd say that. Well, he didn't say anything. And I told him that he needed to work with me to get witnesses and to get the evidence in. And he worked with me. And we got along, and we started the trial. In the middle of the trial, the company offered a settlement. They were going to reinstate these guys. It was about 5 or 6 truck drivers, drink truck drivers. And they said, okay, we'll reinstate these guys and they give them back pay. So I took it to the guys. We asked the judge to give us a recess. The only condition that they wanted was they wanted the money by that night. I told them that was kind of unreasonable, but that's what they wanted. And so the judge gave us a recess until the next day. And the company got the checks and gave me the checks that night. While I was passing out the checks, this gentleman who was in the Klan, he was so happy to get the settlement. He raised bees as a hobby for honey. And he came to me and put his arm around me. He said, Jasper, he says, look, see, if you ever want any honey, you can have all the honey you want if you come down here to Fayetteville. And I didn't say anything, but I was thinking, no, I don't think I want any honey that bad, But it was a moment of humanity, and he got over whatever his issues, and I got over what was. I didn't really have an issue with him personally. It was just that this Klan business, I wasn't too excited about that. But you do what you got to do, and my office. Back to my office and us getting along. I think that was sort of my reputation with the labor board, that I could deal with difficult situations, and so I got difficult cases, and that's sort of my calling card.
Now, was there another big case you wanted to talk about?
Yeah, to illustrate the point of the the nexus between civil rights and labor rights, I wanted to talk a little bit about a case called Enersys, Enersys. And this was a case that came out of Sumter, South Carolina. And Enersys was a battery manufacturing company. They used to be there before they changed the name to Enersys. They were called UASA, YUASA, I believe it is. So around they had a plant in Sumter, South Carolina, and this plant was majority African American and some whites. Around 1995, they voted a union in the plant, and the company was, of course, disappointed and more than disappointed, and they tried their best to keep the employees from voting for that union. Well, they voted the union in the plant. I don't think they got a contract until maybe 3 years later, but they finally got a contract. But the contract was a terrible contract. The employees ended up getting a reduction in wages as a result of this a provision in this contract.
Oh, hold on.
Yeah.
I can hear her.
You want to stop for a minute?
Yeah, hold on, yeah. Okay, so Innocence.
Yes, getting back to Enersys, Matt. Enersys, as I said, was a battery manufacturing plant in Sumter, South Carolina. So the union gets voted in around 95, and the company fights them tooth and nail to keep the union from getting certified. But they get certified, and I think maybe 3 years later the union got a contract. But the contract was not a good contract. And anyway, the company continued its campaign, anti-union campaign, to weaken the union. The union elected officers and tried to just get established in the plant. The company, over a period of a few more years, fired the union president under very difficult circumstances. The union elected a new president. They fired him. They fired about 6 or 7 top union officials, all of which was geared toward undermining the strength of the union. Then they started, they funded an anti-union campaign. There was a gentleman in the plant that they would provide money for him so that he could hold meetings and try to encourage people to oppose the union, to try to decertify the union. They threatened people. They did just about everything they could to weaken that union, to get that union out of there. Well, when that didn't completely work, they decided to transfer the work to 2 non-union plants. And by the way, we issued complaint on behalf of the union and the workers for those terminations, unlawful terminations and threats, and they're supporting this anti-union committee. So the most significant thing they did is they finally closed the plant. And I was assigned by someone in Washington to investigate this case. I worked on this case in Sumter, South Carolina for approximately 3 years. During that time, I'm trying to meet with employees, it wasn't unusual for me to go to an employee's house and talk to that employee only to come back to my office and find out that the company had complained to my bosses about me talking to employees, alleging that I was harassing employees. I was followed. The union had a meeting on one occasion, on a Sunday, and they asked me to attend the meeting. And I attended the meeting on my own time with the approval of my supervisors. Went down and attended the meeting. I held up a copy of the complaint, and I told them that this was my Bible, and I said this because it was a Sunday. I said, this is all I can talk about. Well, I got some questions from people that I had not seen before, and I suspected that these people were plants, as it were. Sure enough, when I got back to the office that Monday, the company had complained that I was making unlawful statements in this meeting, which was a union meeting. All right. So I had to do a report about the meeting. I did a report, then they asked me to do a second report. And I refused to do a second report. I said, I don't remember anything else. You've got all the information I got. But I'm sure that trying to get me to do a second report was just an attempt to get me to snag myself. Later, I was told by a friend of mine in another region that I was under investigation because of that meeting that I attended. I was cleared of any wrongdoing. In fact, the labor board ended up writing a letter to a senator from South Carolina, Lindsey Graham, which showed him that I had not engaged in any illegal or unethical conduct. So the big issue of the plant closure was a great matter of controversy in my office. My bosses did not want to put that in the complaint. They wanted to dismiss that issue. We were going to go to court on the terminations, the discharge of the union officials. But they didn't want to add the closing of the plant in the complaint. And I fought to get that in. They dismissed it. And the union appealed it to Washington. Stayed in Washington for a number of months. It came back, and when it came back, they supported my position. And we were required to put it in the complaint and take it to court. Okay? So now I got to prepare this case for trial. I've been investigating it for 3 years. Now it's ready to prepare. So I get ready to take it to trial, and I'm getting prepared for trial. And one of my key witnesses was a former HR manager who by this time was living in Arkansas. And I go out to Arkansas, Little Rock, and I prep with him. And then I'm going to go back to Sumter and prepare those people. Well, somewhere during this period, the company agreed to a settlement. We ended up settling the case, a case that we wanted to dismiss. We settled it for $7.7 million. And it was quite a vindication for me because in my office, I think I was the only one who wanted to take the case to court, the plant closure. But the case was settled before federal judge Matthew Perry, who is one of the great judges of South Carolina. He had been a civil rights lawyer when I was a child, a teenager growing up, and got a chance to. He's passed away now, but during this settlement meeting, the courtroom was filled with the galleries and probably at least 5 or 6, 7 attorneys, 3 or 4 for the company and 1 or 2 for the union and myself for the labor board. And we presented the settlement to him and he approved it. But before he approved it, just before we completed the business, we had just about completed all the business. I told the union attorney, who was of his age group and knew him personally, I said, I got one more thing I want to say to the judge. And I didn't tell him what I wanted to talk about. So he advised the judge that I wanted to speak. And in the federal courts, you got to step up to the podium. So I stepped up and I said, Your Honor, I grew up in Columbia during the 60s, and I was one of those young people out there demonstrating. You were the person that represented us. You were the person that we listened to. You were the voice of reason. I said, I'd be remiss if I didn't take this opportunity to thank you on behalf of all of those untold individuals who helped to get a better life. And again, I just simply want to say thank you. And he smiled and he appreciated it.
Was he African American?
Oh yes, yes he was. He was the first African American federal judge in the state of South Carolina. He worked on the Brown versus Board case, which was, Brown versus Board came from 3 states: South Carolina, Kansas, and Virginia, I believe it was. And the portion that came from South Carolina, he worked on that case. So here he is at this point. He was in the latter part of his career, and in fact, he passed on probably within a few years after that. But I deem it one of my great honors to have gone and had the opportunity to go before him and to express my appreciation for the work that he did. I'm standing on his shoulders, and a lot of us are standing on his shoulders, but I personally can state that there's a connection between what he did and my efforts to work on behalf of working people in North and South Carolina.
Excellent. Well, that whole story, in other words, were most of the workers black at the NSS place?
The majority of them were, and there were some whites, but most of the workers were black.
And of course, like Smithfield, they tried to divide by race.
Absolutely. And the gentleman that was running the anti-union campaign, which the company funded, which is illegal, okay, was white. And he would hold these little receptions where he had food and drink and all this. All of this stuff was, it came out that all of this stuff was being funded by the company. And he went after most of the white employees, but he also went after some blacks. Because by this time, a lot of the supporters of the union were disenchanted because they lost money as a result of this contract that the union worked out. And I think the union was kind of duped into this contract. They were supposed to have gotten pay raises, but it resulted in wage losses. And the irony of that whole thing was the law firm that represented the company turned around and sued the law firm. After all of this was said, after the settlement, alleging that the law firm had given them bad information. So I don't know how that turned out, but it had a lot of elements to it. But this went on for well over 3 years, and the positive thing about it was that practically everybody who worked in that plant, and there were about 300 to 400 people worked in that plant. Everybody who worked in there during a certain period of time, we designated the time, or received back pay for the plant closure. Not 100%, but we sort of apportioned it based upon years of experience. I think was the primary criteria. And there were people who literally cursed me out, who received paychecks, and of course they were happy about that. But yeah, so that was a big case down there in Sumter, South Carolina, and it was a big labor case. It didn't get a lot of notoriety, although it was written up in the New York Times. But I felt quite relieved that we were able to get some benefit for those employees after they endured all of that upheaval and all of that struggle, and because they were looking at getting nothing. And here again, it was a clash between the company and the union, the workers and the company pitting the black workers against the white workers and those who were opposed to the union. And most of the supporters of the union were black. And that's usually the case. And where you get a union that's successful in organizing the plant, they have to get the support of the black employees if you're organizing in the southern states.
Of course, it seems like all the rules and everything are in it. You know, the companies have a lot of power, obviously.
Yeah.
In terms of things like captive audience
Yeah.
meetings and
Yeah.
all that stuff. So it's a miracle when the unions are able to prevail, like Smithfield's a good example.
It is, and it's a very difficult task. It's a long struggle. We used to say, when I said we, those of us who work for the labor board, we'd say the union's got to lose one to win one. In other words, they have to lose one election before they have a possibility, if they stick around for the second, a possibility of winning a union election. But they have to overcome a lot of the threats. And in the laws, the labor laws are not as strong as they need to be. That's difficult. And hopefully, in this administration and future administration, we can strengthen those laws, because it's employees going from if you are terminated from your job, and then you got to go through the whole process with the labor board, the investigation, the trial, the company's going to appeal it. All of that just takes too long. Yeah. And it's not that we're attempting to do it, but you know, it's the process. Companies sometimes do additional acts of threatening unfair labor practice acts just to keep that investigation going. As long as the investigation's going, we've got to investigate it. That prolongs the trial. And this case this Innocence case is a typical example. We shouldn't have taken 3 years for us to get to court. And we ended up settling it just before we went to court. But that's part of the strategy.
Right. Well, kind of moving towards closure, we have about 8 minutes left.
Okay.
You know, at one point Dr. King said a statement, I'm not going to be able to say it right, but he said that it's wonderful to have civil rights, but the ability to put food on the table, to have any semblance of, say, a middle class life, or at least one where you can provide food and shelter to your families and all that, that's huge. And so you, in your long and storied career, have really been helpful, incredibly helpful, along with your colleagues, to help do that, despite all the fact that the labor laws are weak in this country, especially compared to other countries, say in Europe or whatever. So what are some of your thoughts about that? In other words, we have to keep fighting, and unions are, of course, are vilified, but what else can a worker do? If you're a worker at Smithfield or McDonald's and you don't like conditions, and you say, look, I'm demanding $15 an hour, and they're going to tell you to get the hell out of the store. You know.
Yeah. There's another aspect of what we did that I'd like to talk a little bit about. It's called protected concerted activity. Protected concerted activity simply means group activity, coming together of employees to work toward improving terms and conditions of employment. You don't need a union for that. All right? And to make the point here, I'll tell you about a case I had. I had a case, now I can't remember the name of this case. Years ago, I had a case down in the PD section of South Carolina, which is toward the coast, before you get to the coast. And there was a plant down there that made gaskets. The employees were primarily African American women. It was a foreign company, and they employed mostly African American women. So they had a period where they were working 7 days a week. And the employees were disgruntled about it, and they had a meeting about production. And toward the end of the meeting, one of the employees, Mrs. Moore, who was known to be a religious person, stood up and told the manager that she asked the manager when they were going to stop working these 7-day-a-week shifts. She said that she and some of the other employees wanted to be able to go to church, spend some time in church with their families. His response was that this was about production, and if she didn't like it, essentially, she could leave. So she continued talking about that. She was joined by another employee who essentially said the same thing, that she wanted to be able to take time off. Well, he stopped the meeting, took those two employees, these were two black women, took them into a private meeting. He said, Mrs. Moore, since you like to take off on Sundays, then you're fired, and you can go to McDonald's and flip hamburgers. Maybe you can take off there. All right. He didn't fire the other lady, but he fired Miss Moore. Now, the meeting was heated. She said some things, he said some other things. We issued a complaint on it. We took it to court. And the question was she engaged in protected concerted activity by speaking up about her work hours? And I did some casework on it, and I did some research on it, and my conclusion was that she was able to convince my office, and we took it to court. So we get before the judge, and I prepped her and prepared her. We get before the judge, and she got agitated. And the company claimed that she called him a devil, all right, which she denied. But I was able to get one of the supervisors, when he got on the stand, to admit that even the supervisors were concerned about these 7-day-a-week work weeks. And the supervisor said, nobody liked those work weeks. And I said, well, did you talk to any other employees who made these? Yeah, he admitted. So the judge discredited Miss Moore. It's maybe the only case I ever had where the judge found that she in fact had called him a devil. But he also found that she complained about the working hours. And she was joined in that complaint by the other employee, and even the supervisor admitted that there was complaints from other employees, albeit not in that meeting. So the judge determined that this was a matter of general concern among all the employees in the plant. That she was, albeit she was not a chosen spokesperson, but she was in fact speaking about a matter that concerned all employees. And he found that this was a violation of the law for them to terminate her and ordered her reinstated with back pay. So if you're an employee, you have a right under the National Labor Relations Act to speak up about onerous hours, working conditions, wages, anything having to do with your work. You don't necessarily have to have a union to do that. You can do that as, and usually it may be better for employees to get together themselves and speak with one voice, but it doesn't have to be a formalized matter. So that's just an example of some things. But you're right. I think that I've tried, and we've tried, those of us who work with the labor have tried to do some things to try to improve the working conditions and wages. And usually, generally speaking, if we can get through this process, and wages are going to increase when you have a union, because you got someone to negotiate for you. And employers and the unions can request information to show the profitability of the company.
We're done.
All right.
0. So that's still recording though, but I don't know how. Well, any final, if it is still recording, any final thoughts in terms of the theme of the unsung heroes? You're a hero.
Well, I don't quite think of myself as a hero, but I'm happy to say that I got this opportunity to work in this field, to do something to help my fellow man, and to do a job that I generally enjoyed. And it wasn't a walk in the park sometimes, but for the most part, I feel like this job was a job that I was suited for, and I'm glad to be at this point, having retired after 40 years, and I have good memories of working with strong, courageous people to try to improve their working conditions.